Thank you, Chair. Thank you, Mr. President. I suppose it's safe to have that imperial designation acknowledged 3 weeks before the Queen's visit in this fine Georgian building. I'm delighted to be here in this fair city, which has contributed so much to the dynamism of the English legal profession over the last few years. I don't say that provocatively or flippantly. Indeed, I say it a little bit wistfully in circumstances where so many of the brilliant lawyers that have left this jurisdiction to come to London and other parts of England and Wales have returned home in recent years after some very expensive training at the expense of the partners of Clifford and elsewhere. So I think we have a little bit of a score draw on that for the present. Someone said to me outside, isn't this all a little bit oxymoronic? Business, law, human rights, aren't those in some respects mutually exclusive? Or at least isn't there a tension amongst them between those three subjects or topics or areas? And I hope to show that there are ways in which they can be yoked together, particularly in the modern era. Human rights law has, after all, been institutionalized over the last generation. What was the exotic pursuit of postgraduate students at some universities has become mandatory in many universities. Human rights law has been domesticated in a number of countries, such as the UK. And of course, human rights law is an area which corporates, which business has opportunistically exploited for many years, to the great annoyance, it has to be said, of many NGOs in the process. It seems to me you can't be taking one of the tobacco cases in Dublin currently without knowing your way around human rights. Plainly, you can't be a media lawyer worth your salt these days without knowing the implications of Articles 8 and 10 of the European Convention. And it's an interesting and salient feature of the development of the great multilateral human rights instruments of the world, such as the UN Declaration or the European Convention of Human Rights, that many of the initial cases were brought by business on its own behalf. So even if, which I think would be regrettable, you had no interest in engaging in public interest litigation on behalf of the poor and vulnerable, if pro bono was a bourgeois indulgent conceit that wouldn't enter your head, if you want increasingly in the modern era to service international clients, whether before the courts in this jurisdiction or help service them internationally, you need to be on top of the relevant human rights concepts. And of course that's part of a wider trend whereby corporate responsibility has become mainstreamed. In the summer of 2005, The Economist magazine had a special supplement which concluded more or less by saying that Milton Friedman was right. The business of business is business. The only constituency to which a company owes obligations is its shareholders, and corporate social responsibility was a nice to have but not terribly important. Economist produced another supplement last year charting the fact that in the 5 years that it intervened, the corporate responsibility landscape had been completely transformed, and that major businesses, valuing their reputation, valuing their need to build sustainable futures for their brands and their staff and their shareholders, needed to be credibly and systematically engaged in the corporate responsibility space. So on that score as well, even if you're disinclined to do some free lawyering for the public good, take care to ensure your clients aren't ahead of you on a lot of this stuff. because they will be demanding that you service them to the best possible degree in this jurisdiction and elsewhere, and you may find them very savvy on this score. And they, of course, have reputational obligations of their own, whether parochially through the legal department of their establishments or at main board level. My old firm, Clifford, gets about 3,000 invitations to pitch each year. So that's, dozens each working day. It's very unlikely in the modern era that those pitch documents will not require there to be some serious manifestation of your firm's corporate responsibility credentials. The really cute ones will say in their RFP, in their pitch request, we shall expect those who turn up for interview to become our panel lawyers to tell us what they personally do in the pro bono area. And I've had a number of delightful and interesting conversations with alarmed relationship partners at Clifford Chance, wondering if they can contrive to invent a pro bono track record overnight, something I resolutely decline to help them with. But that's the nature of modern business, and I'd be surprised if that already hasn't happened to numbers of you. So there are client pressures on practicing lawyers to raise their game in this area.